Welcome to the Smart Legacy Podcast, your resource for protecting assets and securing your future. Hosted by Stockton and Kandt, join us as we cover essential estate planning and elder law topics, such as wills, trusts, and Medicaid planning. Stockton and Kandt, your trusted attorney advisors in safeguarding what matters most. Welcome to another episode of the Smart Legacy Podcast. I'm your host, Glenn Stockton. I'm the managing attorney for the law firm of Stockton and Kandt, located here in the Kansas City area. We have offices in Overland Park, in Corporate Woods, and also an office down in southern Johnson County in Gardner, Kansas. I have in studio with me today my daughter and partner attorney with the firm, Sophia Kandt. So, Sophia, welcome.
Thank you. Excited to be back.
All right, today our topic is going to be who should you choose as your helpers and fiduciaries. So as we're putting our plan together, we've got some choices to make. So we're going to talk about who those people should be today.
Who's going to be stepping in and filling all the various roles involved in putting that plan together. So I think we really need to start with a bird's eye view of what roles are there that we need to be discussing. So there's a lot of different roles here. One of the roles is going to be an executor, or the modern term for executor is a personal representative. But that's a person who is named in your will. That document is a contract essentially that says when you die, this is who gets what. Goes through probate, and it's not in effect until you're dead.
So the person you're going to name is going to assume this role after your death, because
Right.
a will does nothing for us while we're alive.
Right.
Who do you want to carry out your wishes as expressed in the will under the supervision of the court?
Right. Yep. So that's one of those roles. It's that executor, the personal representative. Another role is going to be the trustee. That's a decision you got to make. Who's going to be your trustee if you have a trust? So a trust, what a trust is it is a document that you can set up while you're still living. We are big fans of trust. There's a lot of benefits in a trust. You know, we say this all the time, but we're not a firm that thinks that a trust is for everybody. There's a lot of benefits that a trust provides. And if those benefits are important to you, then a trust is a good idea. So when you create a trust, if you think of the trust like a safe, right? You're creating a safe, and then you're going to move your property, your assets, your home, your bank accounts into that safe. Then the safe typically has a key, right? You've got to lock up the safe. Well, while you are alive and well, most of the time you have that key. So you are typically the trustee. That's your role. If you've created the safe, the trust, then you are the trustee. But what happens if you can't serve in that role anymore? You can't be a trustee. Well, now you've got to give that key to a backup person, so that successor trustee role. And that's where that comes into play. So we've got an executor through your will that's appointed under the terms of your will. We've got a trustee appointed under the terms of your trust. And then we go to, there's lots of various documents as well, a financial power of attorney, a general durable power of attorney, or a property power of attorney. We'll see those different
All
terms.
terms for the same document, right? Just the financial power of attorney.
Right. Right. And so that document is appointing somebody, there's another role here, somebody to make financial decisions on your behalf if you are no longer able to. And that role is going to be an agent under your power of attorney, or we'll see attorney in fact is another. It doesn't have to be an attorney when you see attorney in fact, and I think that confuses a lot of people. But that role is called an attorney in fact or an agent under that power of attorney.
It's just who are you giving power of attorney to manage your finances, property, and money when you can't.
Right. And a lot of people understand it as, oh, I'm the power of attorney for so-and-so. And that's fine. That's how people describe it, what they talk about. So if you see someone, someone is the POA for somebody else, that's what that means, is they're the agent appointed or the attorney in fact appointed under that person's power of attorney. We also have a healthcare power of attorney, and there's a role within that document as well. Right now we've got to appoint somebody to make healthcare decisions on our behalf if we're no longer able to do that. a very vital, important document that is necessary, and thinking through who's going to be that person or persons is a decision, something that we'll definitely be discussing today, but that's going to be a healthcare agent. So far, just kind of recapping there, I've got additional ones, but recapping, making sure that we're kind of following along, is executor under your will, a trustee under your trust, a agent or attorney in fact under your financial power of attorney, an agent under your healthcare power of attorney, and now in HIPAA, a person named under your HIPAA. So what that HIPAA document is, it's a document that names certain people and gives them the authority to receive your healthcare information, for doctors and hospitals to release that healthcare information to those individuals. And so that is an important role that it needs to be filled. And so something to be thinking through is, who are you going to be naming under that document? And we'll go into that, as well as a guardian. So when you think about a guardian, who's a guardian? Well, typically most people think about guardians as a guardian for minor children, right? A parent dies or becomes incapacitated, and that's typically how we think of guardian. So that guardian is managing that child's life, and they're choosing where they're going to live, what school they're going to go to, all of those things. So that if you have minor children, that's a role. It's an important discussion to have, and a role you're going to want to make a decision on before you get to that point. So naming a guardian for your minor children, if that if an event that requires that should occur. And then, you've got all these documents in place to prevent you from needing to go to get the court involved, right? We prepare these, and a big reason that we prepare these documents is to not be a burden on our family. Having these documents in place before something happens, making these decisions, thinking it through, making these important decisions ahead of time, so that we don't end up in a situation where we haven't made these decisions, and now we've got to go to court to have a person in a black robe now make these decisions on our behalf who know nothing about you, and it costs money, it takes time. So if we do get into a situation, let's say that we have created documents even, right? We've created power of attorney documents, but we went online, we downloaded one online. It wasn't state specific. It didn't provide the necessary powers that we need in those documents. We see this all the time. But that power of attorney, through that power of attorney, you've appointed a guardian for yourself. So even if that power of attorney document actually doesn't provide somebody the necessary powers, at least you've indicated, okay, should I go to court, have to go to court then, or my family have to go to court for me on my behalf to manage my affairs? Well, you can also appoint a guardian through those documents. So that would be a guardian not for a minor child. That would be a guardian for you if you become incapacitated. And a conservator as well. That would be another role. So lots of different roles. I mean, I'm sure I could come up with many more roles that we may fill in, right, if we need to, depending on how complex or different situations, depending on your family dynamics or things going on in your life, we may fill more roles. But those are important things to consider as you just name, one person after another. Those are all decisions we got to discuss today. So
I think if it came down, it's really, these are roles that people may have to play at your death or your incapacity. Mm-hmm. And it's that you choose who's going to play these roles versus a court choosing who's going to play the roles. It's not like by avoiding this, we're not going to need them, right? These are going to come into play through facts and circumstances, incapacity, death, who's going to be the one to take on and get things across the finish line or do whatever needs to be done. But the idea is that you get to choose who it is. And you have these various documents, give various powers, and choosing wisely and giving thought to this is important.
Right. So how do you choose who that person or persons will be? And I think you've really got to evaluate from a lot of different perspectives. You need to evaluate, if you're going to appoint somebody to make healthcare decisions on your behalf or to make financial decisions on your behalf, serve as a trustee. Those can be big, very important roles. And those roles may often take a lot of time, and it just may require a time commitment from that person serving in that role. So thinking through who's going to be serving in those different roles, I think there's different qualities to look for in that person.
Yeah, but I think for most people, I think this comes in that it's kind of natural of who's going to serve in those roles, right? Most commonly see it, okay, if I can't do it, it's going to be my spouse. If my spouse can't do it, I'm going to look to my children, one or more of the children. So who's going to play the roles often feels very, very natural. Certainly there are situations where that's not the case. We don't have people playing the role, or the people that are our family are not appropriate either through they have issues of their own, whether it's they're incapacitated, they've got dementia, they drug issues, there'd be all kinds of things that can impact this. But I think for most people it's natural. But what's not natural, where I think people, they really don't think this stuff through. We don't have the crystal ball. I don't have a crystal ball. You don't have a crystal ball. None of us do. And I'm not sure what's going on in the lives of these people when they have to assume these rules, to assume the duties. And so where I think, and I know you agree with me on this because we've had lots of discussions about this, and where we help our clients try to go through is, okay, let's think it through. What does this look like? And we can't know for certain because I don't know, maybe I've named a child to serve a role, but when that happens, I don't know when I'm going to lose capacity, when they have to assume the role. Maybe they're battling some serious health condition. They're going through cancer treatments, or they have a sick child, or a sick spouse is going through serious health issues. They've got something crazy going on at work. I don't know what's going on in their life. And so I think if we think through these things and we have discussions, and that's what we like to help our clients do, let's think this through. You're naming this person, okay? So you've got this natural person you believe should serve in that role. You believe they're trustworthy. You believe they have the capacity to make the decisions. But what if they don't at that moment? What if they don't have the capacity because they're dealing with other things? They've got something crazy going on in their life. Have we thought through? Well, we can name somebody else to come in and serve to back them up at that point. Where are they located? Well, in today's mobile society, they might be your local boots on the ground on the day you name them in that position. But by the time they take over, they live clear across the country, sometimes clear across the world. And that doesn't necessarily mean they can't serve in that role, right? But there are considerations to be made. So it's going to bring us into the things that hopefully we'll have time to talk about today about, how do you review these? How do you, stay on top of this? But their determinations, I think, as you're picking who is going to serve in the roles, obviously to make sure you trust them, that they have the capacity and the competency to do this. But there's also other considerations to think through. Right.
Now, a lot of people may think, in naming a trustee of my trust, or naming, these positions, these really important positions in my estate plan, right? A lot of people like to name your spouse and your children. But for those more sophisticated roles, like let's say a trustee, a lot of people think, well, it's, do they need to be an attorney to serve in that role? Do I have to hire a trust company? Maybe there's a good reason why there are attorneys that serve as trustees and trust companies, but it's not a requirement that you have to be an attorney or a professional trustee to serve in those roles. So, looking at it from, does that person have the competency, the financial competency to make decisions? Are they responsible? Do they understand? Are they a numbers person? They don't even have to be a numbers person, but do they get it? Are they responsible with their money? Do you think that they're going to be responsible with your money? That's an important discussion to be had. But again, back to kind of what you said before, is that we don't know. We may say, right now they're very responsible, and maybe forever they will be responsible, but that's not the only consideration. We don't know if they're going to have children of their own at the time, other health concerns, if they move across the country, all of those things come into play. So, no, it doesn't. To answer that question of does it have to be a professional person or a professional company to serve in those roles? No. And we may have different people serving in different roles. There's not a one size fit all solution to all of this.
I am a big believer in professional trustees. I just don't believe everybody needs one. In fact,
Right.
I think the majority of people have natural, the family members that will serve the role. So most of our clients do not have professional trustees. But professional trustees, boy, they bring a lot to the
Yeah.
table, right? This is what they do. They understand trust. They understand the laws. They understand taxation.
They can be the person to be the bad guy, right? If you have children and they're fighting and they're trying to decide how to sell the house, making these decisions, how much should we sell it for, and they can't decide, and so they're going to look to, if you appointed your oldest child to serve in that position, now that oldest child has got to be the person to, make the decision, potentially be in that position where they're the bad guy. But if you appoint a trust company to serve, that trust company is happy to be the bad guy and take that burden off of your family, preserve that relationship.
They're going to be able to manage that. And so, they can serve that role. They can also serve the role for people who have, they own businesses, or their kids just have a lot going on, that's like they're raising their own children, and I'm going to be throwing in, I say business owners. This can be a good one. You got to start winding down the business and trying to sell it off or get things moving on because I'm either incapacitated or I'm dead or I've got multiple rental properties, real estate. That can be a lot to throw onto your family when they're already, their cup is full with things because they're living life. And so, when we see those kind of things, it's always, back to do they have capacity? Not can they do it, but is this going to be fair to them? Because the number one thing we hear from clients of why they do estate planning, I don't want to be a burden. So keep it simple. Don't overcomplicate this stuff. Simple plan's almost always the best plan, but sometimes we have complexities in life we're just going to have to deal with, right? Don't make it more complicated than it needs to be. Be comprehensive in planning. And most of the time, your loved ones are going to serve in those roles, and we need to make sure that we're thinking it through, how we're going to divide up responsibilities.
But when you made a comment earlier is that, we don't have that crystal ball. We don't know what's going to happen in the future. And we see so many times where a person comes in and they've done that trust online, or they've done that simple trust with the, financial planner. They love to do those trusts, but they're not comprehensive. We want to keep it simple, but they're not comprehensive. And we'll see trusts that are a few pages long. They're not covering a lot of things that actually may happen in the future. And so when we do our trusts, you'll see that our trusts will be pretty lengthy in size. And, we are very big proponents of keeping it simple. And our trusts are going to be simple to administer, simple to understand, but it's going to be comprehensive and cover any and everything that may happen, because the last thing we want you to have to do is go to the court and have the court decide, okay, now we didn't talk about farm property. At the time, they didn't own farm property. Now the trustee bought farm property. There's farm property in the trust. What do we do? Okay, we've got to pay attorney fees, all this. We don't have to involve the court. So when we need to be comprehensive in how we name fiduciary. So we name our child, our spouse as agent, as trustee, but we need to make sure that we have the ability to be able to change that up if it's necessary. So one of the ways that we can do that is, okay, we name our child as trustee, but we don't know if when the time comes that they have to serve in that role, if their cup is full, if their cup is too full to take on this role. Well, in our trust, what we make sure is that trustee has the ability to do a couple things. One thing would be that trustee has the ability to hire professionals. If that child is not a numbers person, not a tax person, doesn't have the time, the capacity, the availability, all of those things to be able to file taxes on behalf of the trust, do things like that. Well, the trustee can go hire a CPA. The trustee can go hire an attorney, go hire all these different positions, go hire a professional to help them with it. They can also go appoint a co-trustee to serve with them as long as they are serving. So they could go appoint their sibling, another individual to serve with them and take on certain roles that they don't feel that they have the ability to take on at the time. They can also resign as trustee and make sure that if you've got a backup, always be thinking through, if that one trustee can't serve, that one fiduciary can't serve in whatever role you've appointed them to serve, make sure there's always backups to them serving. But there's a lot of things that you can do. Keep it simple, right? We want to keep your plan simple, but be comprehensive and allow for all of these life changes that do happen to be able to happen, and your plans still go according to plan, I suppose.
So as you're going in, I'm listening, and I think it's easy to think, wow, this seems so complicated. Mm-hmm. There's so many decisions that have to be made. And what we would tell people is like, there are a lot of decisions to be made. And it's back to not having the crystal ball. We have to make decisions that probably will never come into play. But I would rather think this through, make the decisions, appoint people, and then never need them than to need them and have never thought mm-hmm. this stuff through. And now we're having to involve the courts unnecessarily. So we look at our job as helping them. We refer to them as sweaters in the suitcase, right? Mm-hmm. Back to keep it simple. Your plan should be simple to understand and administer when you're alive and well, simple to understand and administer at your incapacity, and the same at death. But we don't have that crystal ball, so we're packing some sweaters in the suitcase as we go through this journey of life. I hope nobody ever develops special needs. But what if they did? Mm-hmm. Well, we need to have covered that. I hope that the person you appoint is able to carry out those roles. But what if they're not? We've got a backup that comes in. So there can be a lot of sweaters we pack in. Hope you never need long-term care, nursing home. But if you do we have a plan to deal with that? That's one of the legs of our planning. So we got to make sure we're doing long-term care. So we pack these things in. Don't let them get in the way of the simplicity of this. But as we're going through and having the discussion of who should serve the different roles, so a trustee is one of those. One thing that we can see and can do, but we rarely see, certainly, I've never seen one in the, do-it-yourself kind of things, or these ones that are, as you said, there's financial advisors who've decided to get into the, estate planning business and using AI and technology to help mm-hmm. draft trusts, and all kinds of issues we see with those. But even with that, what we never see is we can bifurcate. We can trifurcate responsibilities. I can have a mm-hmm. distribution trustee who takes care of the distributions. I can have another one who's handling the aspects of managing a business or making sure they're handling the tax aspects of things, where we can divide mm-hmm. up responsibilities that go in. So, what we try to do is understand what are the needs, what's the competencies and capacities of the people involved, and are those things to consider. That being said, rarely have I ever used that ability where we bifurcate the responsibilities of a trustee, because again, it adds a level of complexity. We go there mm-hmm. if we need to, mm-hmm. and that's our job as attorneys, to try to help our clients, make informed decisions that are going to be, help make this thing work and keep it easy, but only go there if we need to go there. So right. I think consideration to make. All right, so that's qualities we're looking for. What are some of the pitfalls that you see commonly that coming in? Because I can think of several where I see mm-hmm. what I would call common pitfalls as people are choosing who's going to serve these different roles as their fiduciaries right. and helpers.
Right. Well, I'd say one of the most common ones that I see is when a parent comes in and it's automatic. They say, I have a healthcare power of attorney. I'm going to appoint my children to make healthcare decisions on my behalf. So it's going to be my oldest child, because that's the order, and I don't want to choose favorites. It's going to be my oldest child as number 1, my middle child as number 2, and my youngest child as number 3. Well, that may be fine, may be okay, but have you evaluated all of these qualities that we talked about previously? Is that oldest child the most mature? Are they going to be able to make the hard decisions if that time comes under your healthcare power of attorney? I don't know, that those are things that we need to think through. But that is the most common thing that we see, is just appointing people according to the birth order.
I think one of the things I've observed over the years of working with lots and lots of individuals and families, helping them put estate plans together, the hardest decision that they make when they're putting their estate plan together is when they have minor or dependent children. Who is going to be the guardian of their children? Painted with a little bit of a broad brush. Some people, this is not that difficult decision. For so many people, that is the toughest decision they'll make. And again, part of it's they don't want to hurt feelings. There's nobody that's perfectly positioned to be able to do that, because maybe they've got these people, but they're starting to get older. Do they have the energy and capacity to be able to do so anymore? Or I'd love to have this person, but they live, clear across the country, and now my child's going to be ripped away from everything that they know. They've lost their parents. And so that's one they beat themselves up on, is who's going to play that role. But then the next one is we're having to pick between our kids to play these different roles, whether it's the power of attorney. And so what they'll try to do, well, I want to be fair. We don't want to hurt feelings of kids. We love our kids equally. We don't want to cause problems. So it'll be based on either, like you said, well, I'm just going to do it in birth order, or, well, I'm going to appoint this child to make finances, but I'm going to appoint this one to make healthcare, because that way I'm being fair and I didn't pick favorites. I'm dividing up. Well, was that the best decision? And so what we tell clients is we don't necessarily even have to choose between them. We can appoint them as power of attorney, co-trustees. They can work together. And just because, one lives closer, it doesn't mean they're going to be, closer when the time comes. Or this one's more appropriate, it doesn't mean they'll be the more appropriate. Things change over time. But those are things we see people beat themselves up about. But I agree with you. One of the pitfalls is they're trying either not to hurt feelings and be fair, and so in how they divide it up, or they'll pick some random order, whether it's birth order, or, well, I'm going to pick this one because they're closer, which can be a relevant discussion, but those are things that should not be the sole determining factor, or even necessarily the primary determining factor.
Right. Another common pitfall that I do see happen often is people will, I've got two children, I'm going to appoint both of them to serve together, but they don't really get along very well together. But they have different opinions, and, maybe one is a nurse and the other is closer here, but they don't really get along. But so they appoint them to serve together, or they're not trying to choose favorites, so they'll do that, right? They'll have them both serve together. And if you appoint people who do not get along well, that is asking for problems, and people don't think that through. And something I find a decision commonly made in power of attorneys and documents.
Yeah, and I think for a lot of families, that's one that I think can make a lot of sense, of appointing, putting the kids in there together. We don't have to pick favorites. They can come in. But if they can't even be in the same room together, they can't communicate well. If one just constantly runs over the other, and you observe that, let's be honest about this. We can choose one over the other. We don't have to choose the kids at all. We can appoint somebody else altogether. Now, if we do this right, they don't have to get along perfectly well, right? They can have, because if we make the big decisions, we take some of these decisions away from them, there's a lot of the stuff they're probably not going to be fighting over. So again, there's just no cookie cutter recipe that says here's how to do it. But there are considerations. If they can't be in the same room together, putting them all in the document together is probably, that's not going to just fix it. Like, okay, now they'll get along because I've named them together. Okay. Any other pitfalls that you see that comes in on a regular basis?
I think a pitfall that I see is not revisiting and updating your documents as life happens. So if a child that you've appointed gets sick or ill, or you've appointed your spouse and they die, or your child that has lived local and has been that boots on the ground child, now they marry somebody and they get a job and they go off to the other side of the country. They're no longer that boots on the ground child anymore. Life happens. And when people don't revisit their plan, what we do at our firm is we revisit the plan on an annual basis, a yearly basis, because things happen. Things are going to change all the time. And oftentimes, every year to year, things aren't changing that much where we have to go and we have to update the plan. But it requires that we review it to make sure that these are still the people that we want to serve in that role. So that's, I think, one of the biggest common pitfalls that I see as well is just not revisiting and updating when that time comes, when it's necessary.
Yeah, I think, you said we like to have what we call the annual review come in, and and we don't jump up and down and pound on the table if somebody misses a year. Usually I reserve that for year 3 to say, come on guys, give me 1 hour out of your year. This is important. But if we can create this cadence of just once a year, literally it's about an hour a year to come in. And in those annual reviews, we're confirming our plan choices. Here's who you named to make financial decisions if you can't make them. Here's who you've named to make healthcare decisions. Here's who you've named as your beneficiaries, the executor, trustee. We're just confirming those choices. Is this still the appropriate person or people to do so? How's your health? How's their health? How's everybody getting along? Has anybody moved away? Is there anything that's changed just through life that's happened that's going to make this maybe not the choice we would make today if we were doing it over again? Because, I like to tell people, your estate plan, until you become incapacitated or die, it's wet cement. It's got a firmness to it, but it can be changed. It's not completely hardened and set. That happens when you die. Now, whatever you had, it's set. But we can make changes to this stuff. So we just review, are these the appropriate people? We're also reviewing, have any laws changed, anything that might, affect the documents, but also might affect how somebody should be appointed that comes in. Because sometimes, not often, but there can be some changes in law that might impact the choice of having somebody who would be doing this out of state. For example, would they have the authority to do so? So I think reviewing it regularly, not reviewing it regularly, would be the pitfall that we see frequently made.
So I know from previous discussions, and I am as well, but a big believer in naming multiple people on a healthcare power of attorney. And I think that is something that is very rare and that you don't find really ever when we review other healthcare power of attorneys, ones that are done online, done from other people. And that's something that people aren't thinking through. How does this actually play out? If I'm appointing one person after another on my healthcare power of attorney, typically most people appoint the spouse as the first initial agent and then their one child as a backup, right? And that's typically as far as it goes. We don't see it go much further than that. Sometimes we'll have a third in play. The more we can have backups, right, the better, because if the first can't serve, then the next serves, and we're avoiding that need for court involvement by having those additional role or people serving in those roles. But what happens if you've put, your child in that position to make the decision, and if you become incapacitated, if you get injured, you become ill, and you go into the hospital, and that child that you've appointed, going back to a phrase that you used earlier, their cup is full, right? They've got a full-time job. They've got children at home, sending children off to college. Their spouse is also busy. They've got children going in different activities, different sports. They've got a full-time job. Maybe they have a business on the side as well. They're going to school, all these different things that may come into play. But they're appointed to make your healthcare decision. So that person, that child, feels like their life essentially has to be put on hold while mom or dad is in the hospital. And that's going back to a common pitfall we see is through that power of attorney naming just one after another, is that you've put them in that position where they feel like they've got to do that. They've got to be there for you. And so I know that you're a big believer in naming multiple people if we can, and if we have the ability and they work well together, naming multiple people to serve together on a healthcare power of attorney.
Yeah, but yet literally every healthcare power of attorney that I see, that whether they had another attorney drafted it, they did it online, they did it didn't matter where they got it. You got it from their doctor, the hospital. Almost every healthcare power of attorney does the same thing. If I can't make healthcare decisions for myself, I appoint this person. And as you said, common way it goes, my spouse. If they're married, if my spouse can't do it, then it's this child. Maybe it goes one further than that to the next one. Although most of them stop at 2. is there anything wrong with that? And I say, no, not necessarily. In fact, for probably the first 10 years of my practice, because that's just how it's done. And I would ask, okay, who do you want to serve in this role? Okay, if they can't do it, who's the backup? But what I observed over the years is I would see the toll it was taking on people, especially if there's any kind of extended stay in hospital or nursing home or assisted living,
Right.
clients who can't make decisions, and the toll it takes on the caregivers. That was one thing that influenced me. The other is this mobile society we live in today. And yes, technology, they don't necessarily have to be local boots on the ground. They can come in. But people were moving, dynamics were changing, they were career changes, they moved across country because they took on a new career, and they're working tons of hours or traveling. And it was a huge burden to put onto these kids to come in and serve on behalf of their parents. And so as I looked at it and started coming in and saying, okay, and looking at how families were actually dealing with those situations, and other kids were stepping in, but they weren't appointed to make it. It made it more difficult. So I said, what if we just start appointing this? Let's have the discussion. And, as I always say, just because you can doesn't necessarily mean you should. How do they get along? How are they going to be able to do this together? But you don't have to pick favorites. You don't have to choose only one. And it works well when they get along relatively well. As you said earlier, if they can't be in the same room together, we're not going to fix that by just saying we're going to name you together. But yes, I'm a big fan of at least considering that. Is that appropriate for you to have multiple names? And that can be true for healthcare. It can also be true in all those other positions as well. It can be one, it can be multiple people, but let's just think through, what does this look like when we get there? Back to not having the crystal ball.
Right. So we've gone through, we've made these decisions, we've chosen people to fill these roles, and we just put our documents away and put them in that locked box. And we talked about, we want to take them out and we review them. And let's say we review them on an annual basis every single year. And then at the end of the year, we put them right back in that locked box. Are there any issues with that?
Absolutely. So, 2 meetings at once for every client we have. When we do a estate plan, I want to make sure that, number one, they get in that cadence of getting into the annual review, right? And if it's not every year, then at least every couple years. But hopefully once a year, we're getting together, we're confirming plan choices, we're looking to make sure that assets are all titled properly, beneficiary designation correct, that the plan works. But the other meeting that we like to have, and we don't charge those annual review meetings, the other one we like to have, we don't charge for, of course, is the family meeting, right? And our clients can decide which family members they want to go. They can bring as many or as few as they want. But certainly the people that are playing these roles, do they know that they're playing a role? Do they know what it looks like? Do they know where they're going to find the documents when the time comes? In Kansas, if someone dies with a will, that will has to be delivered and filed with the court within 6 months of their death, or it's no longer valid. Did they even know that one existed? Will they know where to find it? Do they know that they have a duty to deliver it to the court within 6 months? And so when we have that family meeting where we can go through and so I'll use the common example where mom and dad have done the planning and they've appointed the kids, so we bring the kids in the family meeting. We want to know, mom and dad have a plan. Here's what you need to know about the plan. Here's where we're going to find things when the time comes. Here's what your roles are in the plan. And I usually let them know, and by the way, if you guys argue and fight over this stuff, mom and dad will come back and haunt you relentlessly for the rest of your days of your life. And I wrote it in the plan, so I can't do anything about it. Don't do it. But that family meeting, we're trying to set them up for success. We want them to know the plan exists, where to find it, but I want them to know other things too. Is there a lockbox at a bank somewhere? Is there a storage unit they need to be aware of? Do they know how to get passwords? Are they going to know where to find this? So by doing the family meeting, our goal is to be that trusted attorney advisor for our clients. We're meeting with them on an annual basis. We're tracking their assets. We know where their bank accounts are and all this if they're taking us up on these annual reviews, because we're updating that every year. So I want the kids to know about us, because if we've done this planning right, if something happens to mom and dad, I want them to reach out to us. And as I tell them, look, I'm not charging for that meeting, that phone call. We're going to walk you through it. We put together what we call the 911 checklist, what to do at incapacity, what to do at death. I tell the kids, you don't have to remember this. We use a red, estate planning binder, and a red tab says 911 on it. I'd say, guys, all you have to remember, red binder, red tab. but I want them to know where we're at, right? And just so they get an overview of the plan. And we find that transparency goes a long, long ways in keeping family peace. And so we're going to go through and let them know what happens at death, who's making the decisions, whether it's all of them, whether it's one of them. At least they know mom and dad made these decisions, or whoever, that made the decision. So just having those things in place is so, so important, and making sure they're available wherever you're at. So we like to use DocuBank, a third-party company, where we can upload our clients, healthcare directives at a minimum. But it's more than that, right? So they're available 24/7 wherever they're at. If they go into the hospital, hospitals have access to this. First responders have access. But not only that, they know what medications, if any, you're on, pre-existing conditions, personal health history.
They've got contact information for the people that need to be there and be in the know and help make decisions.
So it's just thinking through to make sure that this stuff works when we get there. And as estate planning and elder law attorneys, that's our goal, is to help our clients keep it simple, don't overcomplicate it, but be comprehensive. So there's a lot that can go in this, and it doesn't have to be overly expensive. It doesn't have to be overly complicated, but it does need to be comprehensive, or it's just not going to work well, because life's going to throw you curveballs, and you got to be prepared for it. So do the planning, and keep it up to date. Look at it periodically.
Right. Yep. I agree.
All right. Well, I think we are out of time here today. So with that, I would just encourage listeners that if you find this information to be relevant and helpful, subscribe, share, like the podcast. Help us get the word out here. There is a lot of information we'll be presenting in future episodes of this, so tune in for those episodes. You'll also find a plethora of information, love using that word, a plethora of information on our website at stocktonlaw.com. You'll also find links to the podcast there. So tune in, and we hope to see you on a future episode of Your Smart Legacy podcast.
The information provided in this podcast is for general informational purposes only and does not constitute legal advice. Listening to this podcast does not create an attorney-client relationship. Laws vary by state, and this podcast focuses on estate planning and elder law in Kansas and Missouri. If you are located in Kansas or Missouri and require legal advice, please contact our office. Otherwise, consult a qualified attorney licensed in your jurisdiction.